Hello, everyone. Good evening. Thank you for joining us tonight for this legal and HR update. My name's Ada Smilovich. I'm a partner and head of schools HR at Winkworth Sherwood, and I'm joined this evening by Teresa Kerr, who is a partner and head of schools support service at Winkworth Sherwood. And we've also got Andrea Squires, who's the head of education, joining us slightly later on in the session. We've got quite a bit to get through this evening, and we are hoping to give you an opportunity to ask questions or generally feedback or comment on some of the content you've heard, or even put questions to us in relation to other issues that you might be facing within your schools or trust. I'm going to pass over to Teresa to tell you a little bit more about our education practice. I appreciate that you might be very familiar with it, and then we will go on to the content for the evening. Thank you, Teresa.
Thanks very much, Ada. And yes, absolutely. Good evening, everyone. It's really nice to have you, your company this evening, and for you to give up your evenings to hear about our legal update. I'm thinking and hoping that many of you do already know us, but maybe for those of you who don't, we have a large education practice at Winkworth Sherwood, and we support schools on their kind of whole life cycle in terms of setting up academies and multi-academy trusts, and then providing legal and employment law support on the range of issues that might crop up on a day-to-day basis. So we're a growing team, and we advise on, in my team anyway, a whole range of issues from parent complaints, GDPR issues, admissions, exclusions, SEND, safeguarding, crisis management, and all sorts of other sorts of day-to-day issues that come up. Ada heads up our schools HR team, and her team advise on a whole range of HR issues. So from the sort of day-to-day sense check-in on maybe long-term health issues, grievances, disciplinaries, right through to employment tribunal disputes and complex litigation. So we're very much hoping in terms of this legal update to give you the benefit of our insight and analysis, rather than hopefully just a boring legal analysis, which, let's be frank, no one really wants to sit through. It's more the kind of insights I think that which will be beneficial in this session. So we've got our schools HR and school support help desks, which again may well be familiar to you or members of your your teams in your schools. The contact details are there, and as I just said, we'll share our slides so that you've got them to hand. It's the sort of thing that might be useful to post to your notice board or your desktop, just in case you or your colleagues need to contact us for urgent support from time to time. In terms of this session, I'll be handing over to Ada, who will give you a HR update, and obviously the key topics are just outlined on the slides there. Ada will then be handing over to me, and I'll be covering off the Children's Wellbeing in Schools Bill, which has received a fair amount of press since that was issued before Christmas. And then Andrea Squires will be joining us later on in this session, and she'll be talking about the impact of MACS, and obviously through the lens of the diocesan strategy. Very happy to take questions throughout. We're really keen that this is an interactive session as much as possible, or often with these sessions it's beneficial for others to hear maybe thoughts that you might be having in terms of the topics that we'll be covering. We'll obviously keep an eye on time so that we can get through the content. So perhaps if there's particular issues that's during animated discussion, we can pick those up later on if there are those themes. I think we're anticipating a 2-hour session this evening, so we've got this in the diary till 8 o'clock. We'll perhaps see how it goes. We may finish early if you're lucky, but we'll see how we're going in terms of time. As I say, it might depend on the amount of discussion and questions that we have, but we're happy to be quite flexible in terms of the time that we'll take up this evening. So I think if that's all sounding in terms of what you've signed up for this evening, I'll hand over to Ada, who'll give you her insights from a HR perspective.
Thank you, Teresa. So hopefully we haven't lost any of you. We've still we've still got you interested in some of what we're talking about this evening. Before I go on to some of the substantive HR and legal updates that I'll be talking about, I just wanted to sort of cover quickly the common themes or issues that are coming across both the help desks, because I always think it's helpful to let you know what we're seeing, and it may well be the same as the themes and developing trends that you're seeing, and certainly if not, it's perhaps something to be aware of and look out for. We're seeing a lot of redundancy and restructure. That's probably the top theme this term. A lot of trusts and schools, academies are looking at cost saving for obvious reasons, and also becoming more efficient and running more like an effective business. So we are being asked to support redundancy and restructure, whether as a managing the whole project or reviewing business cases letters or providing template letters, as the case may be. We've had a lot of fire and rehire issues come up, and trusts or schools looking to make contractual changes to staff terms and conditions, and that can pose various legal risks and needs to be handled very carefully, particularly with the introduction of the statutory code of practice on fire and rehire. Safeguarding is always a common issue across both help desks, often straddling both help desks, because often a safeguarding issue may also relate to staff misconduct or something going on in a member of staff's life outside of work, for example, an arrest or an allegation within the family that also needs to be managed by the school. Sickness absence management, always a hot topic in the sector, as you all will know, and again needs to be handled very carefully. Teresa, you'll probably agree we're seeing a lot of complex parental complaints and a lot of complex staff misconduct cases that often require or have regulatory implications, and also have result in an increased demand for independent investigations, which I've put there as a common theme as well. We're seeing an increase in vexatious claims and complaints, what we call have a go litigants or have a go complainants. I think that's because people are just being creative about making some extra income. The economic climate is such that people are more likely to pursue a claim or complaint. We're seeing trusts and schools receive letters from the DfE or Ofsted where a disgruntled parent or a disgruntled employee is unhappy about how something has been handled, so they will escalate it to the regulator. And as Teresa said, crisis management, a lot of reputational risks, managing communications and also media inquiries has been a common theme this term as well. So just some things to be aware of, some things that we can assist you with, and it may well be that you're grappling some of these issues yourself. A theme that I wanted to discuss with you this evening is neurodiversity in the workplace, because it is a very tricky area, and there are common pitfalls that a lot of employers, not just within the education sector, but more generally, can fall into if they don't handle these sorts of cases sensitively and carefully. So the purpose really is to give you a case law update so you can see how fact sensitive these cases are, and how on very similar facts the courts and tribunals have come to very different conclusions depending on how an employer has handled the situation. So neurodivergence is in most cases a disability under the Equality Act. It's estimated that approximately 3 in 10 people mask their neurodivergence, so they cover it up because they're worried about stigma or stereotyping, or they just want privacy and they don't want their employer to necessarily know about it. Masking itself is known to cause significant mental health issues, which can also of itself amount to a disability. It's helpful to know that in January this year, ACAS published new advice on neurodiversity in the workplace to help employers with the type of language they're using, to help them create inclusive organisations, and to also raise awareness of neurodivergence in the workplace. It's also important to note that people who are neurodivergent can actually contribute positively to a workplace, but might have issues that they need their employer to support them with and manage so that they can work effectively and efficiently. Before we move on to the case law, I just wanted to remind everyone of the definition of disability. It means under the Equality Act that someone has a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. It's quite a low threshold. Most mental or physical impairments will satisfy it, provided that it's lasted or more likely to last 12 months or more. And crucially, there's no requirement for a formal diagnosis. So it doesn't matter if the person has a diagnosis. If they say, I have ADHD or dyspraxia or dyslexia, if they don't have a formal diagnosis, that of itself doesn't prevent the condition from being a disability under the Equality Act. In terms of the types of disability discrimination in a neurodiversity case, there are varieties. So you've got direct discrimination, indirect discrimination, failure to make reasonable adjustments, discrimination arising from disability, harassment, victimization, and associative discrimination. Most of the cases that I'll be taking you through this evening, certainly the ones involving disciplinary action or dismissal, are claims brought as a discrimination arising from disability complaint. That's a Section 15 Equality Act complaint. And that's where the employee who's the subject of the disciplinary says, yes, I behaved badly or I breached a particular policy with my conduct, but that conduct is arising from my neurodiversity or as a result of medication that I take or something along those lines. So where someone raises that issue, it then complicates matters in terms of progressing the disciplinary and potentially issuing a sanction. That doesn't mean that you're prevented from taking those steps. It just means you need to handle it in a particular way. It's also important to note that in these types of complaints where someone says it's arising from their disability, an employer does have a statutory defence if they can show that whatever steps or sanctions they put in place, those steps or sanctions were proportionate means of achieving a legitimate aim. So one example, for example, is to safeguard children's health and well-being in school, or to comply with a statutory obligation under keeping children safe in education. In most cases, that could be a legitimate aim. So the key is whether the steps you took were proportionate to achieve that legitimate aim, and sometimes dismissing someone under the disciplinary policy may well be, as you'll see in the cases that I'm going to cover. So the first case is McQueen and General Optical Council. This is a recent case, 2023. The employee had autism, dyslexia, and Asperger's, and he was disciplined for rude and aggressive behavior. He said that the rude and aggressive behavior stemmed from his neurodiversity, and there was evidence that he could get angry or aggressive if he was given instructions verbally, so the employer had implemented reasonable adjustments whereby instructions were given to him by email. In the course of the evidence and having heard from both sides, the tribunal actually said that the behaviour had nothing to do with his neurodiversity conditions and actually stemmed from his personality, and he was just not very good at taking instructions. He appealed that outcome, and the tribunal's decision that this was not an unfair dismissal was upheld, so the employer actually succeeded. The harassment claim was also dismissed. However, he had a successful victimization claim. So where the employer tripped up, they handled the dismissal perfectly, they handled the disciplinary great, no harassment, but where they tripped up is he raised a grievance, and that process was delayed by some 18 months, which caused him all sorts of anxieties. So he was still successful in that complaint and awarded compensation in excess of £20,000. The key advice for employers from this case is to obtain medical advice and implement adjustments to manage the discrimination risk, and to ensure that if something arises in the process you're following, for example, a DSAR or a grievance or someone goes off sick, that is handled properly to avoid subsequent victimization claims. George, I'm going to take your question. Did George mean to put his hand up?
Sorry, microphone switched off. Yeah, just regarding your earlier statement that you said that an employee doesn't have to have a formal
Diagnosis.
qualified diagnosis. Yeah, that's the word.
Yes.
And yet you've just said that we can seek medical opinion. Isn't that a contradiction?
No, so the medical opinion would be to inform to what extent any alleged neurodiversity contributed to the behavior, whether any reasonable adjustments to the process are required, and so on. So it's essentially an occupational health referral. It's not really asking the expert to give a diagnosis.
Yeah, okay, that's what I thought you meant, occupational health, right? Okay, yeah. Thanks.
Thanks, George. Good question, actually. Good clarification there. I'm then going to take you to Morgan and Buckinghamshire County Council. And in this case, it did actually relate to safeguarding. A social worker with autism, dyslexia, and other conditions was dismissed for giving gifts to a child without permission and writing an inappropriate case note. The employer actually accepted that she was disabled for the purposes of the Equality Act, and she was dismissed for misconduct for those two acts, for giving the gifts to the child and writing an inappropriate case note. She alleged that those actions were the result of or arising from her disabilities, and the tribunal accepted that they arose from her disabilities. However, and George, we just spoke about occupational health, she refused an occupational health assessment. So the employer didn't have sufficient evidence upon which to assess to what extent the behaviour arose from her disabilities. And secondly, whether it would arise again, whether she would repeat the behaviour, in which case, if she was going to repeat the behaviour, it became more difficult to manage the risk. The tribunal also found that whilst the dismissal was for conduct relating to her disabilities, it was a proportionate means of achieving a legitimate aim. So one of the points that I raised at the start of this part of the session. The aim in these circumstances was the maintenance of professional boundaries to protect vulnerable children. So very much in line with keeping children safe. The claims for unfair dismissal and discrimination arising from disability were both dismissed. And the key takeaway, she did appeal, and she wasn't successful. And the key takeaway from this case is that a lack of occupational health advice affected the employer's ability to consider whether adjustments could be implemented to prevent the behaviour from recurring again. And of course, one of the things that crosses our mind as humans is, well, maybe we just don't make an occupational health a referral, in which case we won't be on notice of it. But I think that would be a failure of itself. In this case, the employer made it and the employee didn't engage with the process, and that's where she fell down. And much like the McQueen case, although the unfair dismissal and arising from disability claims failed, this employee succeeded in her disability-related harassment claim. And this is because the appeal outcome letter said that her masking her autism was a concern and inferred that she had been deceitful by masking it. And I spoke earlier about masking and why people did it. And the tribunal found that this amounted to harassment under the Equality Act because it violated the claimant's dignity and created a hostile environment for her. And that was upheld on appeal as well. So I guess the advice from this case is be cautious about the language we're using in formal communications, because again, the employer would have been home and dry on all the claims if they hadn't had that poorly drafted letter. And another one for you, City of York and Grosset. This actually concerned a teacher, so very relevant to us. He was a teacher who suffered from cystic fibrosis. He had adjustments in place for his conditions, but they were not formally or properly recorded. A new head teacher started and placed him under increased stress. He complained about deadlines and workloads, and he mentioned specifically his condition when he asked for a reduction in work. The workload wasn't reduced, and he then, as he says, as a result of all this stress and pressure, made the poor judgment of showing an 18 rated film to a class of 15-year-old pupils. He was the subject of a disciplinary process, and he showed remorse at the disciplinary hearing. He accepted that showing the film was inappropriate. He said it was an error in judgment. He held his hands up, but he did say it was stress linked to his disability. The employer didn't accept that explanation and dismissed him for gross misconduct. The Employment Tribunal dismissed the unfair dismissal claim. They said the dismissal was fair, but they held that it still constituted discrimination arising from disability, which crucially still succeeded even though the employer was unaware that his actions were linked to his disability, or they said they were unaware. At the time they dismissed him, they said they were unaware of the conduct the conduct being linked to his disability. But the evidence that the tribunal heard said it was possible to conclude that from everything available to the school at the time, that it might have been linked, and that was enough. The school appealed to both the Employment Appeal Tribunal and the Court of Appeal, but those appeals were unsuccessful, and the sums involved in this case were significant, and Mr. Grosset received damages of in excess £600,000, which is obviously a lot of money. And I think what stands out in this case as compared to the previous ones we spoke about is that he did hold his hands up. He admitted that it was poor judgment. He accepted that it wasn't appropriate, and it just seems a little bit disproportionate to have dismissed him on these facts. And I think that's where the tribunal was coming from in making a finding that it was discrimination arising from disability. Where I think the two conflict, though, is they found that the dismissal was fair. So it's interesting that they could make both findings in relation to the same facts. George.
Yeah, sorry, me again. How does this case, being it was a safeguarding incident, how does that play against the legislation and the requirements of schools on safeguarding? Because surely from that point of view, it was the correct action no matter what.
Yeah, you're right. And I think that's the key point. Schools have to be satisfied that it is proportionate, that the step you are taking, i.e. dismissing someone, is a proportionate means of achieving a legitimate aim. So the legitimate aim being safeguarding, and so it's proportionate to dismiss this individual. But I think where he gained sympathy is that he was upfront and honest at the hearing. He didn't try and make excuses. He accepted he did wrong. And I don't think there was evidence that the behavior would be repeated if reasonable adjustments were made, for example, reducing his workload. So that's the key when you are making a decision to dismiss, to make sure that it's proportionate. And what that could look like is going through the different sanctions and concluding why they're not suitable, why dismissal has to be the outcome.
A supplementary question then, if this wasn't a disability case, would that have been fair grounds for dismissal?
Yeah.
Okay, thanks.
And that's one of the findings. They actually said on ordinary unfair dismissal, he doesn't succeed. Yeah, exactly.
Right. Okay. Yeah, thanks.
Kate.
Yeah, hi. Just a kind of supplementary question, I guess. So you've just said there about one of the reasonable adjustments could have been to reduce the workload. Where do you then stand of reducing the workload as a reasonable support in comparison to all your other colleagues undertaking the same duties, without that then being discriminatory?
Yeah, absolutely. I think each case is judged on its own facts, and you would have to consider what it is he's asking for that would help or support him with his disability. So a reduction in a workload may just mean a small reduction, but at the same time, it doesn't matter what the effect on his non-disabled colleagues is. It's about the obligation to him to make reasonable adjustments. And often, Kate, and you'll know this, there is disagreement between employer and employee about whether something is a reasonable adjustment. But I think in this case, there wasn't even a consideration or an acknowledgement that that might have prevented the behaviour.
Okay, thank you. I suppose another question to that, however, would be that it doesn't matter what the impact is on everybody else. However, well, if there is an impact on everybody else.
Yeah, no, it matters. So that's one of the considerations, the impact on others, whether you've got resources to redistribute the work, cost is a consideration, but not the only consideration. So there is a statutory code of practice from the Equality and Human Rights Commission that sets out what should be taken into account when considering reasonable adjustments. And if you don't follow it, the Employment Tribunal will have regard to that when considering whether you complied with your duty. So it is onerous, I acknowledge that, and it can be very difficult when you're trying to run a school and manage your staff. I'd also say that this case is, and as I said at the start, they are very fact sensitive. So we've had several cases where the finding was against the employee, probably on the same facts or similar facts. So it really depends on each individual employee, what their disability is and what adjustments they're asking for.
Okay, that's great. Thank you. So what did you say? Statutory code of practice for reasonable adjustment?
On the Equality and Human Rights Commission code of practice, it supplements the Equality Act, and it's really helpful actually. It sets out considerations when looking at reasonable adjustments. It explains each protected characteristic, gives you working examples of different scenarios. So it's really, really helpful. I can send a link with the slides so that you've got quick access to it. But yeah, it's a kind of go-to. And in any discrimination complaint, the Employment Tribunal will look at whether the employer has complied with the code.
Okay, that's really helpful. Thank you.
Thanks, Kate. Moving on from the disciplinary and dismissal cases, I looked at some statistics today just to prepare for the session, and unsurprisingly, there has been an increase year on year in the number of employment tribunals, tribunal claims that have been brought, which include neurodiversity discrimination. So in 2022, it was 102. It was 17 in 2020 and 93 in 2021. I don't have the statistics for the subsequent years, but it's obviously an upward trend, which I'm not surprised about. And the fact that ACAS is issuing guidance to employers specifically on this point would indicate that it's a prevalent issue or something that keeps arising in the workplace is certainly something for us to be aware of and be thinking about. I looked at a couple of cases today from 2023, just in relation to job applicants. And this ACOM case and Malon found that a failure to allow an applicant to make his application orally rather than complete an online form was a failure to make reasonable adjustments. But I would caveat that with, you can't make that adjustment unless you know about the condition or the disability and the adjustment has been requested. But it's just I'm just bringing it to your attention in the event that you do have a job applicant that says, look, I have can I apply by another method or something like that? Maybe think about it before kind of saying no straight away, and certainly, speak to us. We're happy to give you a steer. And then this second case of Duncan is where the individual had autistic spectrum disorder, and he was expected to call in sick by telephone. That was the requirement under the policy. And the tribunal found that it was a failure to make reasonable adjustments to allow him to report sick in writing. And it was also discriminatory for them to have spoken to his mum about his health condition. I didn't read the facts about why they did that, but for obvious reasons, data protection, special category data, duty of confidentiality, they shouldn't have obviously done that. So I've set out here some kind of practical advice for you when looking at misconduct or disciplinary action. And I would say that sometimes, and I appreciate this is the case, sometimes you're not told that the misconduct is linked to an underlying health condition or a disability. And you may not be told until much further down the line, for example, at the disciplinary hearing stage or even at the appeal stage. But if you are put on notice of it, the key is not to ignore it, deal with it, consider it. It doesn't mean you have to come to a different finding, but you have to show that you have taken into account that element of the employee's defence and still reached a safe outcome. Initial steps in a misconduct case: have a discussion with the employee if they raise a disability and that it might impact on their behaviour. Explore that further. Refer to occupational health, as discussed earlier with George. look at the report, consider whether the effects of the disability are supported by the medical evidence, and look at any reasonable adjustments. Consider whether the misconduct is likely linked to the divergence. Evaluate the likelihood of repeat misconduct, and this is one of the key issues that came out in that social worker case, that the employer didn't have evidence that she wouldn't repeat the misconduct, so the only proportionate outcome to comply with safeguarding was to dismiss her. And the other case where Gusset, where he acknowledged his wrongdoing, accepted it was the wrong thing to do, and showed remorse, that is obviously relevant to the outcome in the same way as any other mitigation that's advanced by a non-disabled employee. As I said earlier, do go through the process of exploring alternatives to dismissal, particularly where it's a first offence and the employee shows remorse. But I appreciate that in, safeguarding trumps all, we all work in the sector and we know that that's the case. So if dismissal is appropriate and proportionate, then you'll have to make that decision and explain to the tribunal why that's the case. But certainly take advice if it's this sort of complicated scenario. I've got a slide here about managing the occupational health and GP relationship. I'm going to leave you to read that in your own time, because I'm conscious that I've spoken about this topic for quite some time now, and we've still got quite a bit to get through. So the other area I wanted to talk to you about is legal professional privilege, because we are coming across more and more savvy employees or savvy union reps or solicitors arguing that privilege attaching to certain legal advice or certain communication has been waived inadvertently, and seeking disclosure of documents. Now, you'll appreciate the correspondence between you and your solicitors or your advisors should remain confidential and not disclosed to the other side, and it could be very damaging if it did have to be disclosed. So I just thought it'd be helpful to summarize very, very quickly the law on privilege and legal advice and certain communications that are not legal advice, because it will just help you kind of manage that risk a bit better. Now, I'm not saying any of you are doing this, but it's certainly a theme that we're seeing. So it's just helpful to be aware of it. So legal professional privilege, as I said, protects confidential documents and communications from disclosure to a third party, including to a court or tribunal, or in response to a data subject access request. It means you don't have to hand it over. Once privilege is established, no one can override it. So the court can't say you have to disclose it or they have to see it or anything like that. There are two types of legal professional privilege. Legal advice privilege, that's limited to solicitor and client communications, where the dominant purpose is the giving or receiving of legal advice. And the key to note there is if you are taking advice from a HR consultant or an external advisor who's not a qualified solicitor, the advice is unlikely to be privileged, which means it's potentially disclosable. The second limb of legal professional privilege is litigation privilege, and that's broader. So it covers not only solicitor or client communications, but also client and third party. So for example, your HR consultants, but only where the dominant purpose is advice or information in connection with existing or reasonably contemplated litigation. So an example would be where you've had contact from ACAS, for example, and you're discussing it with your HR consultant. That would likely be covered by litigation privilege, but not legal advice privilege. The issue of waiver comes about where we, in most cases, inadvertently waive privilege, and that happens where the confidentiality attaching to the communication is lost. So something is legally privileged only if it remains confidential. So the more people you share it with, the more likely that it could be argued that privilege has been lost. So in the case of us, for example, if we're giving you advice, it's absolutely fine for you to share it internally, because stakeholders need to know what the solicitors are saying to manage risk. But it might be sensible to share it within a limited select group, for example, your SLT or your executive team or your trust board. and also stress to them that it is legal advice and it shouldn't be shared any further. It's important to note that CCing your lawyer into an email doesn't necessarily attract privilege, particularly if the chain or the email does not contain legal advice and is not requesting legal advice. This number 4 is probably the most common one we see, and we know why clients do it. It's to give credence to what they're telling the employees. So often we'll see letters that say, we have been advised that, or the legal advice we have received is. If you are saying that in a letter to advance your case, that may well result in privilege being lost. And the loss of privilege, the advice that we're giving you and the advice you're receiving from us and what you're sending to us, it could be very, very damaging. And the reason is because it's not just a part waiver. If waiver is established, it applies to advice on that issue in the entire matter. So it means we may potentially have to hand over our entire file of papers, which could be very detrimental to the school or trust. Now, that's just a warning. I'm not saying that if the employee or their representative said you've waived privilege, hand over your file, we would just hand it over. Of course, we would argue that there has been no waiver and it remains privileged. But if any of these things have happened, so confidentiality has been lost, it's been shared with a lot of people, it's been referred to in open correspondence, then it will be more difficult to persuade the court that there's been no waiver. So it's just a word of warning, just something to be aware of.
Can I just ask a question there? Does that
Yes.
mean that if a complainant, an employee, whoever, claims that they've taken legal advice, they're putting themselves at a disadvantage?
Yes, so often we will have, I mean, it's not something I encourage my clients to do, but often employees will do that very thing. They will say, well, I've spoken to a solicitor and ACAS and they've told me this. I mean, we could legitimately say, well, you've referred to the advice you've received, so now you have to give disclosure of that advice. I don't think that would be helpful to the employment relationship, particularly if the relationship is still ongoing. But certainly if they've left or there's a claim in foot or they've got a lawyer, I mean, sometimes lawyers put it in their letters, you know, we've advised our client that they've got a claim for X, Y, and Z. We see it all the time. And it's quite satisfactory, isn't it, Teresa, to go back and say, well, can we see that advice, please? Of course, they don't hand it over, but it's just a little bit of a pop at them. So yeah, George, technically you could say to them, well, hand over the advice and we'll consider it. Although I'm not advocating that approach.
No, but it might help in a vexatious case or a persistent
Absolutely.
complainer.
Yeah, absolutely.
Okay, thanks.
Particularly if the relationship has ended, then there's no reason to offer them any grace. On to our legislative update. I'm going to run through this quickly and then hand over to Teresa for the Wellbeing in Schools Bill. It wouldn't be a HR session without mention of our Employment Rights Bill and the progress of it. I checked it today, although it says January here, I did recheck it again, and it is making good progress in the House of Commons. It's at the report stage, and then it will move on to third reading before going into the House of Lords. Expected implementation remains September 2026 at the earliest, so we're not expecting any changes sooner than that, but we'll keep you updated. Just a reminder of what the key proposals are. We've got our unfair dismissal day one right. I think everyone is very familiar with that. And that will be subject to a statutory probation period during which a lighter touch approach to dismissal will be permitted. The probation, they're talking between 3 and 9 months. I think they're leaning, but we'll keep you updated on that as well. Number 3 was a recent one, and it's quite significant. The proposal is that the tribunal deadlines, which we all know are usually 3 months less 1 day from the event complained about, they're proposing to increase that to 6 months, which is obviously doubling the time in which someone has to make a claim. And with all the have-a-go litigants that we are dealing with at the moment, it just gives them more time to think about bringing a claim and to bring a claim. The government are proposing to ban firing and rehire practices in their entirety, but there is some talk about giving some limited circumstances where an employer can do it. And crucially, the ban will likely mean that the dismissal is automatically unfair, a bit like where someone is dismissed for whistleblowing, which is significant. There have been some proposals regarding gender equality. I think this probably covers students as well as employees, and it's adding menstrual problems and menstrual disorders as factors to be considered for matters related to gender. And under separate regulations, employers with 250 plus employees will be required to produce, produce equality action plans. So a MAP, for example, with a large number of schools will hit that number quite easily. And these equality action plans, again, back to the menstrual issues mentioned in the previous bullet point, it will need to include those issues within any section relating to gender. So they're aligning menstrual problems with gender more closely. Statutory sick pay to become a day one right. And third party harassment, which was repealed from the Equality Act, I think in 2011 or 2012, it's proposed that that's brought back in. You'll all know that the duty to prevent third-party sexual harassment, the preventative duty, came back into force last year, but this proposes to extend the protection to any third-party harassment. And also regarding sexual harassment protections, they'd like to expand that to say all reasonable steps to prevent sexual harassment, whereas at the moment it's reasonable steps to prevent sexual harassment. So quite a change there. What we expect this year, they're talking about a single simplifying the employment status framework, moving towards a single status of worker rather than self-employed consultant worker and so on, and strengthening protections for the self-employed. So what that single status means is you'll have a worker and an employee, and that's it. There's no other category. Reviews on reform to parental and carers leave system. I've mentioned collective grievances there, but they're nothing new to our sector. I know the private sector is really panicking about them, but we're used to collective grievances in education because the unions utilise them often. And then the earlier bullet points just deal with non-disclosure agreements and avoiding any clause that prevents someone from disclosing harassment, including sexual harassment. So the bill is progressing, but there are amendment papers every so often that introduce new things or provide further clarifications on some of the other proposals that first came out last year. So we will keep you updated, but I definitely expect the unfair dismissal day one right and the probationary period and the extension to the ET deadlines to be implemented. I will pass on to Teresa for the Children's Wellbeing and Schools Bill. From a HR perspective, it is very limited. It's mostly concerned with pupil wellbeing, safeguarding, and so on. But there are some provisions for you to be aware of from a HR perspective. In terms of the progress of the bill, it's slightly earlier in the House of Commons than the Employment Rights Bill, so it's at the committee stage, but again, progressing relatively quickly. And implementation is expected September 2026 at the earliest, I believe. From a HR perspective, it's proposed that the STPCD is extended to all teachers, including teachers working in academies. I know most of our clients will adopt the STPCD anyway, but academies and trusts are entitled to deviate or disapply some parts of it if they wish. And the proposal is that that's not permitted anymore. But there has recently been a clarification that academies will have flexibility to keep to their pay structures and pay above the STPCD pay ranges if they wish. The requirement number 2 there, new teachers in academies must have or be working towards qualified teacher status and to undertake a statutory induction period. Again, most of our clients are doing this. I'm not aware of our academy clients not wanting to support QTS status or not imposing an induction period. Teacher misconduct is being taken much more seriously, and the prohibition regime is proposed to include teachers in more settings, regardless of their current teaching status. So it will impact anyone who is or has ever been a teacher. and regardless of when the alleged misconduct or offence occurred. So it can be very historic, or it can be after they've stopped teaching. The TRA will still have jurisdiction to deal with it. As I said, anticipated timescales are not before September 2026, but I'm sure Teresa will tell us more. Quick summary there, we've got the Neonatal Care and Leave and Pay Act coming in the 6th of April. This gives an entitlement of 12 weeks of leave and pay for parents of babies requiring neonatal care, which must be taken within 68 weeks of birth. Action point is to check your policies, update them, or implement a new one. And we've got a Paternity Leave Bereavement Act date to be confirmed, but it is expected this year, and it's intended to give a day one right to fathers and partners to take paternity leave where the mother of the child dies shortly after childbirth, and up to 52 weeks paternity leave for bereaved parents. Again, this will require either an update to your existing family leave policies or the implementation of a new one. I've rattled through all of that. Just quickly on fire and rehire. From the 20th of January, the Employment Tribunal does have power to increase any award by up to 25% for a failure to follow the code of practice on dismissal and re-engagement. Now, that's usually where dismissal and rehiring is for 20 or more employees. That's when that kicks in. But I would advise all of you to follow the code of practice anyway if you are in fire and rehire territory, because you would want to show that the dismissal was reasonable. And that's an easy way of showing that if you comply with the code. So I'm sick of my own voice. I'm sure you are too. So I'm going to pass over to Teresa to update you on the Schools Wellbeing Bill. Thank you, Teresa.
Very much, Ada. So yes, I'm going to talk to you about the bill that's going through Parliament at the moment. There's been a fair amount of press linked to it, and I'll probably touch on the aspect that's been most high profile, and I think that's connected to children who are home educated, and I know there's been lots of kind of discussion and sort of political aspect to that as well, so I'll touch on that later. The bill's actually pretty big and there's quite a lot to it, and we've broken it up into sort of different sections to try and help you sort of digest it, and there will be an awful lot of information, so I'm hoping for the purposes of this session really to just give you the headlines, because I think otherwise it will be a little bit overwhelming. We do have our latest edition of Heads Up coming out this week, hopefully, and we've got an analysis of the different aspects of the bill within that article, the briefing that we'll be sending out by email. So hopefully you're on our mailing list, and we've breaking it up by the different topics as well, so that you can sort of click in the areas that might be of more interest to you. So there will be a kind of written analysis of this as well, so don't worry about necessarily absorbing all of the information now. As I say, it's really about giving you some of the headlines. And I think as this slide says, and in a couple of the slides that will be coming up, one of the key themes is absolutely about strengthening the role of education in safeguarding. Certainly on a day-to-day basis, when we're advising schools through our helpline, there is increasingly a frustration, I think, from schools where they can sometimes feel a little bit on the outside in terms of some of those safeguarding discussions that might be happening around pupils, and a sense sometimes that they make a referral and it can then be a bit disjointed. There might be a conversation with parents and then there's misinformation, and it can sometimes feel a bit unsatisfactory, and as this slide alludes to, we do sadly all too often read about those high profile cases where there's been safeguarding failures. I can see there's a question there in terms of being added to our mailing list. I think if our contact details should be on the email, so you're more than welcome to send us an email. We'll pass that on to our marketing team who can add you to our mailing list, so you're more than welcome to come through us that way, or I'm sure Debbie won't mind sort of coordinating if there's people who want to come onto our mailing list. So thanks very much. So following one of the reviews that happened, there was a recommendation that education should become a statutory safeguarding partner alongside local authorities, police and integrated care boards, so that the voice of education is very much there at the table when these big sort of strategic discussions are happening. Being mindful that for lots of vulnerable children, it's school is the one consistency in their lives, and in terms of teachers observing and being the ones to check in who the child might confide in, noticing any changes, and the key goal is to require safeguarding partners to include all relevant education and childcare agencies, so that they're represented at that level. Thanks, Ada. The next slide, please. And again, in terms of linking it to that safeguarding theme, the bill is aiming to establish multi-agency child protection teams, and it's a measure to create a duty for safeguarding partners to include and establish multi-agency child protection teams. Relevant agencies must formalise cooperation through memorandums as to how these teams will operate. And again, it's coming down to this idea that ineffective multi-agency working is a key risk to child safety. So new legislation will mandate that the collective responsibility is there for running these teams, including social workers, police, healthcare professionals, again, education at that table. And there'll be clear rules about how these teams should operate. And again, the idea being better joined up thinking to prevent cases from slipping through the cracks. And the government plans to delay the commencement of these provisions until 2027. I think the reality is there's sort of lots of work to be done behind the scenes to make this a reality, and one that's going to be effective. Obviously, it's not something they can get wrong. Some of you will be familiar with the concept of the virtual school head and the role they play in terms of children, looked after children. So there's a measure to introduce a statutory strategic duty to promote the educational achievement of children with a social worker and children kinship care. So since September 21, virtual school heads have had a non-statutory duty to promote the educational outcomes of all children who have a social worker through their strategic leadership and support. So when the bill comes in, the aim is that this measure will make the role statutory, ensuring that every local authority must have a dedicated officer to champion the educational outcomes of these children. And that's looking at things such as school attendance, engagement, overall achievement. Again, the statistics will support that often children affected by these issues, will have lower attainment, attendance and other, again, safeguarding concerns often surrounding them. So it will certainly bolster the role of the virtual school head, and I think that tallies with maybe some of the other guidance that we're seeing. So, for example, the statutory exclusions guidance has bolstered the role of the virtual school head. So there's an expectation that they will be sort of consulted as part of any exclusion process, and they've got the right to attend the governor's review and an IRP as well if they're involved with a child, and they can make representations. So I think that kind of consistency is starting to emerge in terms of, again, bolstering their role, and so on a practical level, that will be something that schools need to be aware of for children affected by this. Thanks, Ada. I won't touch on this slide in any detail. I think there'll be more relevant slides coming up, but there are changes coming in terms of the employment of children. So, looking to strike a balance between making it, practical and, reflecting more modern practices, but also making sure there's safeguarding safety nets in place for them as well. So the details on the slide if you're interested. Yes, George, you have a question.
Yeah, just to come in there, we do some of our caterers use some of our students in secondary for working, and I think possibly cleaning as well. So it could be relevant.
Okay, right. Yes. So yes, there's sort of the rules in terms of the hours they can work will change. So yeah, I think we've probably put the headlines on the slide there for you. So absolutely, I think it's being aware of those issues that may well be of relevance and making sure that they feed into the kind of guidance and policies and procedures that you have in place. So yeah, by all means, if you've got any sort of follow-up questions, I guess obviously the provisions may well be amended before they are enacted. So it's worth being aware, but also being mindful of any changes that are made before the bill is implemented. And that applies obviously to the kind of employment of children, but also more generally to the points that I'm discussing in terms of this bill. I think one of the areas of this bill that again has probably attracted some publicity is this idea of the free breakfast club provision in primary schools in England. So there will be a legal duty on state-funded primary schools to provide a free breakfast club for all pupils, and that's reception to year 6. The aim of the measures is to give all children, regardless of their circumstances, a great start to the school day, helping to break down barriers to opportunity. And that's obviously the kind of political explanation for the bill. It applies to academy schools, so it's certainly something your schools and any maintained schools as well represented here this evening will need to be aware of. Implementation support from guidance from the Secretary of State to ensure compliance will be rolled out, and there will be a sort of pilot trial process as well before it's rolled out fully. Breakfast clubs can be accessed via schools or via private childcare providers, and there'll be some exemptions, but they're probably going to be fairly limited to schools facing exceptional circumstances. And as ever, the devil would be in the detail in terms of what an exceptional circumstance may be, but we'll have to keep an eye out for that. Another issue which kind of does sometimes attract attention, normally around August, September, when you're having to scramble around finding school uniform, queuing in shoe shops to see if your child's feet have grown. It's all that joy. But the reality is the cost of school uniform can be quite prohibitive for many parents. So it's an issue that's been bandying around for many years. There has been guidance before from the department on schools being mindful of the cost of school uniform, but the interesting thing here is that it's actually going to be placing limits on branded items. So for primary schools, there'll be a maximum of 3 branded uniform or PE kit items required. For secondary and middle schools, a maximum of 4 branded items, as long as one of those branded items is a tie. And schools must ensure affordability and follow the statutory uniform cost guidance, which is already in place. So the definition of branded items, again, just in a sort of broad sense, you'll have to sort of consider the detail as and when it emerges, but it includes items with a school name, logo, or specific design. So, for example, blazers with coloured piping. And I actually had a conversation with my colleague, because my school uniform when I was at school was this sort of maroon tartan skirt. And I kind of thought, well, yeah, that possibly would be classed as a specific design, because it's not the sort of thing you'd necessarily wear elsewhere, or, necessarily be able to pick up elsewhere. It was quite specific. So again, we'll have to look at the detail for those sorts of items. Kilts in specific colours, will those sorts of things be caught? Quite possibly. And obviously that does have a very sort of practical impact on schools and your policies and you as governors and directors in terms of thinking ahead about these sorts of things. And it applies to all compulsory uniform items, including bags and footwear as well. So it is possible to offer optional branded items for parents to buy, and it's also important to be aware that seasonal variations, so if you've got sort of summer and winter uniforms and PE kits, that sort of thing, they will count towards the limit as well. So it is going to be quite narrow. It is expected that the limit will come into force in September 26, in time for the 26-27 school year, which the government is suggesting will give time for schools to make necessary changes to their uniform policies and renegotiate contracts with uniform suppliers as may be required. Now, probably my point of caution is you know, that I still think that's still quite a tight time frame for schools, you know, bearing in mind, again, the practical realities that many schools do have exclusivity agreements with school uniform suppliers. I have seen that there's been a bit of kickback from the sort of school uniform supplier association. I can't quite remember their name, but obviously they've got strong views on you know, this proposed change. And I have certainly advised schools where they've been subjected to sort of fairly hard time from suppliers and manufacturers, where there's been a kind of issue in terms of bringing a contract to an end, suppliers trying to get schools to cover the cost of stock that they're still holding. So I think there's potentially all sorts of contractual issues and things surrounding that schools may run into. So you know, as I say, we'll have to see how this passes through Parliament, if it's amended at all. But it's probably one to start thinking ahead in terms of, you know, do you have those sorts of exclusivity agreements? What are the terms? You know, can you get out of it? And again, we're very happy to advise if you need us to. Moving on now to children not in school, which, as I touched on earlier, is probably one of the headline measures that's coming in as a result of this legislation, again subject to any amendments. And this is new legislation to ensure that children not in school receive a suitable education and are safeguarded. It's arguable that there are already measures in place in terms of ensuring that there are, you know, that children who are being homeschooled receive suitable education, and, you know, that there's that safeguarding net around them. So there is a little bit of overlap with existing, you know, rules and procedures that are in place. It does go a little bit further in some respects, though. So there will be compulsory children not in school registers to be maintained by local authorities in England. And again, that's probably one of the big headlines in terms of learning lessons from recent high-profile cases. But this question about keeping a register of homeschooled children has been, again, discussed in the sector for many years and was previously discounted. But as things stand, it looks like it will, you know, progress forward. So there will be some key requirements for local authorities, and that's providing support to parents of children on the register, making the school attendance order process more efficient, ensure parental consent is required for home. Sorry, that should be slightly rephrased. Parents must get consent in order to home educate in certain circumstances. So, for example, if the child attends a special school or there are safeguarding concerns, so if the child's on a child protection register, they'll need consent before being able to take them off the school's roll. And the local authority will be able to assess home and alternative learning environments before allowing home education. And children must be registered if they are compulsory school age and they're not enrolled in a formal school, receiving education part-time or alternative settings, attending further education settings part-time but not in a school. So it'll be interesting again to see the detail. There's suggestions that there might be some parents who will maybe try to sort of challenge the premise of this legislation, and at the moment that's not necessarily a school concern. It's more potentially, you know, in terms of the government, you know, infringing on, you know, parent rights to choose to homeschool without, you know, state intrusion. But obviously that's to be balanced with the safeguarding concerns that we all know can sometimes be the case. The thing I'm mindful of as well is, you know, for some of these high profile cases that we read about in the news, and tragic cases, you know, many of those children aren't actually of school age, they're preschool children. So it's still sort of, yes, potentially plugging a gap in terms of managing that risk, but there's you know, other risks which hopefully some of the other measures I've discussed will be attending to, and, you know, tighten up the procedures there as well. So just a little bit more detail in this slide about, you know, the various responsibilities. I won't go into, I'm mindful of time, so I won't go into too much detail about all of those. And also, as I mentioned, potentially changes to the school attendance order process as well. So as ever, just we'll have to see as further guidance emerges and the legislation is finalised, so that schools will, you know, can make sure that it's following the right procedures. There's a sense that the new bill will be expanding the scope of regulations, in particular to independent schools, you know, more oversight of those. I think, you know, there's this sense of trying to clamp down on some of these, you know, unlawfully run independent schools. I won't dwell on that in too much detail for the purposes of this talk, but again, perhaps just helpful for you to know in terms of broader changes affecting the sector, including independent schools there. So next slide, please, Ada. And that's just more about that, how independent school proprietors may be affected by these changes. So touching now on academy schools and the national curriculum. When I was a trainee solicitor, I ended up doing an education seat, which is how I fell into the sector back in 2010 when the Academies Act was passed. And I very much remember that one of the key benefits that was, you know, in terms of why I became an academy, you know, there was talk of all, you know, autonomy and those sorts of principles. And certainly one of the big benefits was, you know, academies won't have to follow the national curriculum, although you'll be familiar that in the funding agreement there is a requirement to provide a broad and balanced curriculum. So, you know, there are still some constraints in terms of what academies can do. But what this bill is seeking to do is require academies to teach the national curriculum, which will align them with state-funded schools. And there will be reform reform will follow the curriculum and assessment review and the introduction of a revised national curriculum. As I say, maintained schools are already required to legally follow the national curriculum. I've mentioned the requirement to on academies to have currently a broader, balanced and broadly based curriculum. I think we'll have to see how that sort of goes down in the sector. I'm sure, you know, educationalists perhaps in this, you know, room and, you know, within your schools will have their own views. It's not something we tend to advise so much on. It's, as I say, it's tending to be more of an educationalist issue in terms of the extent to which academies already maybe broadly follow the national curriculum anyway. But again, something for you to be aware of, you know, from a strategic level. Thanks, Ada. Again, just touching on academy schools, this is quite an interesting one from my perspective. So, education provision for improving behaviour. So the bill will contain, again, subject to any amendments, a measure to extend to academies legislation that currently allows maintained schools to temporarily direct pupils off-site to another location, normally an education setting, in order to improve their behaviour. And this is commonly described as an off-site direction. And again, the statutory exclusions guidance contains quite a lot of information about off-site directions. And the intention is to place academy schools on the same statutory footing as maintained schools to ensure consistency of practice. Now, in practical terms, it shouldn't change too much for academies because academies do already direct pupils off-site. It tends to be under their sort of general powers, which sometimes does feel a bit vague compared to maintained schools that have a clear statutory provision that they can point to as their power to direct pupils off-site. So that will be interesting. And the other kind of difference at the moment is that there is statutory guidance that applies to off-site directions, and the exclusions guidance encourages academies to have regard to that guidance, but they aren't currently bound by it. So again, I am anticipating that as a result of this change, academies will also have to follow that statutory guidance in terms of off-site direction. The current rules actually require governors to be involved in the off-site direction process. It's actually a power that the governing body have, and that's something, again, on a practical level that we remind schools when we're being asked to advise on it, that a governor should really be involved in any decision to direct off-site. In the review meetings, we recommend that a governor co-signs the letter directing a pupil off-site, just so that there is that governor involvement. So again, I think it's helpful just to have that on your radar in terms of changes coming up. Super. Okay, thanks, Ada, if you can. Thank you. Another interesting change again for academies is this idea of a power to secure performance of the proprietor's duties. And this touches on new powers for the Secretary of State to intervene in academy trusts that fail to comply with legal duties or act unreasonably in governance or decision making. How that compares, so currently, if an academy is not compliant, the only real kind of teeth that the department have, if they really want to sort of do something about it, is via the contractual arrangements between the trust and the Department for Education. So essentially, the department needs to argue, well, you're in breach of your funding agreement, which is a contract. So the kind of options that the Secretary of State might have at that point is to issue maybe a termination warning notice, which can sometimes feel a little bit heavy-handed. Yes, there might be a breach that absolutely ought to be addressed, and may well be appropriate to issue sanctions, but obviously a termination warning notice is a pretty kind of serious response, and that's really the only real teeth that the department have at the moment. So the idea behind this change is that there'll be a new compliance direction power which allows for intervention, but without having to issue the termination notice or a warning notice. So the idea being that it'll provide a more proportionate remedy. So that means that it will allow the Secretary of State to direct academies to take corrective actions, ensures a more straightforward resolution before taking the more extreme measures like trust removal, and academy trusts must comply, or they may have a mandatory order or a termination warning notice. So yeah, definitely something worth being aware of. I think what's quite interesting though, Ada and Andrea and I have been just talking in recent days that we are seeing an increase in letters that our academy clients are receiving from the Department of Education, seeking assurances on a range of different issues, where the department are receiving complaints from individuals, and that might be touching on safeguarding issues or racial discrimination, misconduct, maybe concerns with a whistleblowing flavour as well. And so I think to some extent we're already seeing the department starting, these letters do seem to be more frequent. So I think we're maybe already seeing the department taking a sort of paying closer attention to these sorts of issues already. So in some respects, although the changes I've just described are important and relevant to understand in terms of the legal footing it will have, I think the idea of this sort of closer scrutiny won't necessarily be anything new, because obviously if an academy trust responds to the Department for Education in a way which the Department for Education considers to be unsatisfactory, the chances are it will lead to further questions, further investigations, and potentially raising broader governance questions, which at that point absolutely the sort of strategic team and the directors would probably be involved in at that point anyway. So I think I know that touches on Ada, a point that you raised at the beginning in terms of this becoming a more frequent thing that the academies are dealing with. Now turning to the repeal of the duty to make academy orders in relation to schools causing concern. And again, I think this has been, there's been a bit of discussion about this in terms of a shift compared to certainly what we've seen, in recent years, and, if you like, the consequences for a maintained school if they received an unfavourable Ofsted judgment. it's become pretty normalised, I suppose, that if a maintained school isn't performing to the standard expected, that's fine. Thanks, George. That they will potentially be rebrokered or asked to convert and join an academy trust. So that's been the sort of picture up to now. But this measure in the bill, if it's implemented, means that they will seek to convert the Secretary of State's duty to issue an academy order to a school maintained by the local authority, which is identified as causing concern, into a discretionary power. So it's softening that kind of process somewhat. This proposed measure will change the current duty to issue academies orders into the most underperforming maintained schools into that discretionary power, as I've said. So currently there is a duty, so the Secretary of State's hands are tied to some extent by the legislation. So repealing the duty to issue academy orders will give the Secretary of State the flexibility to determine what the most appropriate action is to drive the school improvement in each individual case. For the worst performing schools, it's expected that the Secretary of State will continue to issue academy orders, but again, time will tell. Again, from an educational point of view, I'm sure you'll have your own views on this, and obviously this is a legal update rather than kind of the rights and wrongs of the sort of broader policy picture, which I think we're kind of waiting to see how that emerges. But again, helpful, I hope, for you to be aware of that. Thanks, Ada. Another kind of point that's helpful to be aware of is the cooperation on admissions and place planning. So there will be new duties for schools and local authorities, as they maintained and academy schools must cooperate with the local authorities on admissions and place planning. The bill is aiming to encourage collaborative decision making so that the local authorities can fulfil their statutory responsibilities. So key responsibilities that admissions authorities must determine and consult on school admissions arrangements as they do now. Local authorities must coordinate pupil admissions during the normal admissions round as they do now, and all the relevant parties must comply with the code. And in terms of place planning duties, it's about ensuring sufficient school places for mainstream and specialist. Again, I think it's fairly well documented, particularly in terms of special school places, that there aren't enough, which means that there's lots of pupils with really complex needs who are placed in mainstream settings that they're struggling to cope in. Reducing or repurposing spare capacity, and again, it's looking at potentially adding more SEND units, publishing a composite perspective for parents on local admissions, schools and local authorities supporting each other in their statutory duties, and again, aim for reasonable and balanced cooperation, even if full agreement isn't reached. So again, you very much get the theme of that being about more collaboration, and I think that's stemming from feedback and potential frustration that local authorities feel, I think especially in terms of academies, because the local authorities, I think, believe that they don't have so much sway and control over how academies choose to run their own admissions arrangements, and so I think it's meant to mean that the process will be more aligned. Thanks, Ada. There'll be enhanced local authority direction powers in the new bill. So local authorities can direct academies to admit children, just as they can with maintained schools if the bill is passed. The aim is to streamline the process and provide a stronger safety net for vulnerable children, and ensure school places are secured more quickly and efficiently when standard admissions process fails. Academies can appeal the local authorities' decisions to the school's adjudicator, and I think that's an important check and balance, as the slide says. At the moment, because the local authority doesn't have the power to direct academies to admit pupils, what the local authority will do instead is make a complaint to the Secretary of State, because the Secretary of State can direct academies. And we've had experience in a couple of cases involving quite serious safeguarding concerns with the pupil who the local authority has been trying to direct. And in those cases, we've put in representations to the Secretary of State on behalf of the academy, who've, as I say, had, you know, really, in our view, legitimate concerns about admitting a particular pupil on safeguarding grounds. And in those cases, the Secretary of State have actually upheld our client's position, which was encouraging to see from a safeguarding perspective, that the voice of academies was being heard. And so I am pleased to see that there is that scope for an appeal process to the schools adjudicator if this is implemented, so that again there is that opportunity to, you know, make sure that, you know, appropriate, you know, risks are taken into account as appropriate, and there's that opportunity to make representations. So the current powers are based on the School Standards and Framework Act 1998. The changes require new legislation, so there'll be an update to the School Admissions Code, and changes going through the kind of usual processes of consultation and parliamentary approval. Thanks, Ada. So again, touching on admissions, and again, I probably should just pause at this point and apologise. I know I've probably thrown an awful lot of information at you, and I think it probably makes the point in terms of how wide-ranging this bill is. It covers a lot of ground, and you know, is quite a shake-up for schools. So as I say, hopefully if you're only sort of taking the headlines away for tonight's purposes, it's kind of still useful that it's kind of put it on your radar. So in terms of functions of the schools adjudicator in relation to admissions numbers, sorry for the typo there, a measure to enable the schools adjudicator to set a school's published admissions number where they uphold an objection to it. And the aim is to enable local authorities to better influence the setting of PANs to support the needs of the local community. And again, this is very much touching on what I've said about local authorities maybe feeling that they don't quite have the levers they feel they need in order to control admissions. Under the current admissions code, admissions authorities don't have to consult in order to increase their PAN. And certainly with the broader picture in the sector, with some schools having falling roles and struggling to, you know, admit enough pupils to fill a year group, you know, the idea of a school down the road being able to set its PAN at a certain number can have implications, and that's certainly the perception of the government and local authorities. So this new measure is intended to allow the independent schools adjudicator to set the PAN of a school where the objection has been upheld, as I say. It's intended to amend the 2012 school admissions regulations to extend local authorities' ability to object to the adjudicator. And where an objection to a PAN is upheld, the measure will allow the Secretary of State to set it for 2 years, or for up to 2 years, if they deem it's necessary. So, as would usually be the case with an objection process, we'd expect academies to have the opportunity to make representations to the school's adjudicator. And at that point, your schools may well want to get some legal advice in terms of making sure they're putting forward their strongest possible case, if they have, you know, solid reasons for setting a PAN at its level. Thanks, Ada. So this slide just touches on the establishment of new schools. Now, I know Andrea was hoping to join us. I don't think I've seen her come to the room. Oh, is Andrea, you?
I am here.
You are?
Yeah.
Fantastic. Sorry. So I didn't want to steal your thunder.
No, that's okay. Did you want to finish on this one, or do you want me to pick up from now?
I don't mind. I can cover this off if you want. And
yes, why don't you? Because I think what I'm quite keen to pick up on is the implications of all of this new legislation. And I'll focus on that for the last 10-15 minutes of this presentation.
Okay. Super. So yes, so just in terms of the establishment of new schools, the key changes that the proposed bill will end the legal presumption that all new state-funded schools must be academies, and it allows proposals for different types of schools, including voluntary, foundation, special schools and alternative provision academies, with obviously the voluntary angle being of particular interest for us this evening. Local authorities can submit their own proposals as well. So local authority responsibilities will be to ensure sufficient school places for children in their area, which again, I think is a real theme coming through in terms of the bill. New legislation will support better place planning, and then the Secretary of State or regional directors will review and decide on proposals. So procedural requirements, again, just a very sort of high level overview. So proposals must include detailed information from the local authority. They must publicise all school proposals fairly, and we're anticipating fairly detailed guidance in the way that there is currently guidance on school organisation that's inevitably going to be amended to reflect this change of legal position. Before approving an academy proposal, local authorities must consult the Secretary of State, and objections can be submitted to the Secretary of State, who is the final decision maker. So again, be really interesting to see new guidance and how that will set out again the detail that how this will affect local authorities and the legal presumption in terms of opening new schools. So I think that brings me to the end of my section. So perhaps, Sandra, if I hand over to you to pick all of that up.
Thank you very much. And yes, it's lovely to be here tonight. Hello, everybody. I think what I'm aiming to do now is really just introduce some of the, from my perspective, key implications of all of this legislation in terms of the Children Wellbeing and Schools Bill, and start to open up the kind of debate tonight for further questions and comments, really from you. From my perspective, I think the three key changes being brought about by the bill, how those will impact the power to direct academies, the increasing regulation of academies, and indeed whether that has an impact for maintained schools as well, given, in fact, in truth, we've seen quite a lot of regulation of academies over the last few years, but with changes to the Academy Trust Handbook, I think at the expense, in truth, of maintained schools where there hasn't been quite so much focus. So perhaps what we're looking at here is an attempt to create a level playing field. That's probably just going to mean more regulation of academies, but probably more active intervention and oversight of maintained schools, particularly where local authorities are not doing the best of jobs. The second area that I'm very focused on is the sort of emphasis on academies, full stop. There's been lots of talk in the press about whether this is the end of academies, whether this government are going to reverse the changes introduced obviously many years ago now by a Labour government. I think it's highly, highly unlikely that they will go reverse academies. I think they will continue with this sort of mixed economy for quite some time, but obviously try and remove some of those fundamental differences. It does start to beg the question, what kind of provision works best within a community? From a Catholic school's point of view, it's very, very clear that the Bishops' Council have continued to think that a Catholic multi-academy trust is the best way to provide provision across a diocese. So I haven't seen any of the bishops kind of revisit the strategy. And in fact, I think what they're trying to do at the moment is a bit kind of doubling down really on the direction of travel that there has been for the last few years, and try to push through a full academy provision in each diocese. From my perspective, I've certainly seen a number of dioceses who have looked to both encourage that, considering possibly the powers of the bishops to direct schools, governing bodies to make a decision to become an academy and seek an academy order. But more particularly, and maybe Debbie won't thank me for saying this, but I've seen quite a number of dioceses who are now actively attempting to support financially the fulfilment of that vision, the bishop's vision to see all academies. So supporting some of the costs that are involved in the exercise. And I suspect that's a theme that will continue. The interesting thing for me again is that on the back of there being less focus perhaps on multi-academy trust, less focus on schools becoming academies, it justifies the removal of the grants that have been available both to support conversion and indeed to support the growth of multi-academy trusts. In truth, I have been prophesying the removal of the 25k conversion grant for years. I was quite surprised in some ways that it carried on as long as it did. I anticipated at some point either that becoming an academy would just be the thing you had to do, in which case they wouldn't provide a grant to encourage behaviour, or I guess as we've seen here, it's something the government aren't particularly looking to prioritise, and therefore they don't want to provide a grant to encourage that action, that direction of travel. I am surprised, however, that they have removed the grants with regard to growth and viability of multi-academy trusts. So that was a bit of a surprise, I think, for most people. Perhaps no surprise because they've got no money, frankly, but nevertheless, it does create some vulnerability across the sector with regard to the impact of multi-academy trusts, bringing into question again the sort of size question. What is an optimum size for a multi-academy trust? And in truth, there is no perfect size of multi-academy trust. What it always generates the question as to what's appropriate for the number of schools in it, it begs the question around what kind of support, what kind of impact a multi-academy trust wants to have on its schools and within its community. So essentially you're thinking about strategic direction and strategic impact of a multi-academy trust, and making sure you're utilising the resources within the group of schools to be able to achieve those objectives, and whether that's growth or refocus on strategic leadership teams, trust leadership teams, is certainly a question we have seen addressed a number of times over the years, and I think that will carry on. What we have seen are quite a lot of mergers of smaller multi-academy trusts in order to address viability and capacity. That hasn't really happened in, well, I say it hasn't happened in the Catholic sector. It has in dioceses where we've had single academy trusts that have been created in the early days of the programme. That's obviously not the case in Northampton, because we've got we've got two strong Catholic MATs that have been growing naturally, organically over the last few years. Interesting developments in some other dioceses. You'll be familiar perhaps with Birmingham in particular, that are trying to create this kind of super MAT over the course of, well, this academic year. And there may be more consolidation even in the Catholic school MAT kind of picture. That's probably a debate for another day, but certainly that question on size, impact and viability is quite an important one. The other key change that I think is important for us is the presumption that any new school is an academy, which Teresa's highlighted the legislative provisions for. We have struggled for years, in truth, with how to create new Catholic schools. Local authorities had tended never to prioritise new VA schools in their areas, and certainly we've got experience of challenging those decisions by local authorities to not look at increasing or having diversity of provision in an area, and kind of tending to presume that any new school should simply be a community school and not provide a religious education. But of course, the free school programme, which became the main tool for opening new schools, was not available to the Catholic Church because of the 50% cap on admissions. So we weren't very happy with what local authorities did, and frankly, we weren't very happy with what the DFE did either. And there had been some talk for some years about breaking that barrier down, removing the 50% cap on admissions. Previous government, I think, had started to move in favour of it. And obviously, in a sense, this government has done away with the idea of a presumed academy, so that isn't quite the same point anymore. But we can, again, focus on new VA schools. And it may well be that the department will help to intervene where local authorities are not giving proper consideration to what should be a diversity of provision across an area. The other irony, of course, with cancelling the presumption about free schools is that they have now cancelled the free school programme, which was entirely focused this time, the latest round, on special provision, special schools. So having cancelled the programme, we've now got less new provision in the pipeline than we had before. So perhaps again something will be done about that. Although in our experience, we're seeing quite a lot of money placed on new SEND units within existing school sites, and that, in truth, we've seen both in terms of Catholic schools and other schools. So that might address some of the need, although I suspect not fully. The other interesting thing in terms of new school provision is with regard to independent schools. Of course, independent schools have had their fair share of change over the last few months with the introduction of VAT on school fees and the reduction or the removal rather of the charity relief against business rates. And the sort of well-documented challenges both for Catholic schools, Catholic independent schools, and other smaller, well, not that Catholic school, independent schools are small, but other challenges to independent school provision. We've been exploring with various bodies the possibility of independent schools converting to voluntary aided status. So essentially, you put forward a new proposal for a new VA school, utilising the site of an independent school, and looking to transfer pupils from one provision to the other. We've actually done it a few years ago for a Muslim school, and I think that's an area of potential opportunity in diocese and certainly across the church more generally. The one area of funding that I'm particularly interested in relates to school improvement. Whilst they've taken away MAC growth grants and school improvement grants that came on the back of MAC growth, MAC capacity building, we have seen the introduction of these RISE teams. I can never remember what RISE stands for. Regional oh God, I really have forgotten. I've got it written somewhere. I'll remind myself in a second. But basically, these RISE teams are now the answer to schools causing concern. So rather than become academy, go into a MAT, be turned around, these teams, improvement teams, will go into a school and impact on the systems, governance and leadership. Interestingly, of course, these RISE teams are going to be advisory rather than directed or directive. Question how much impact they really will have if actually decision making about change is still vested, frankly, in a governing body that aren't really appreciative of the challenges that the school are facing. What I do think is a real issue there is where these people are coming from. There isn't an awful lot of capacity in the system. In our experience, quite a lot of school improvement capacity is in maths. And so I'm expecting the regional directors and the regions group teams to be talking to maths about supporting the work of these RISE teams, indeed possibly even forming these RISE teams. And that, I think, is an opportunity for us in order to potentially generate grant income or yes, well done, there you go, regional improvement for standards in education. It gives us an opportunity, as I say, to generate income from the work and to support the capacity that has been developed, and indeed you want to continue to develop. I also think that maybe in some circumstances there might be conditions attached to the work that a MAT might do. In truth, it's probably not quite such a need within the Catholic school sector, just because actually there are very few poorly performing Catholic schools. But that might be a question which from time to time is relevant. One other area that's worth bearing in mind, though, particularly in terms of, again, continuing on this journey of all schools in a diocese becoming part of the MATs that have been set up, is how to fund, as I said, the cost of conversion. I'm worried less about, in truth, the costs to the governing body and the costs to the MAT, which frankly can be managed, certainly by talking to lawyers who don't charge a fortune. But it's local authority costs that I'm particularly nervous about. And you'll be familiar that many local authorities now charge for conversion. Sometimes those costs relate to their costs. Sometimes those costs are more of a penalty to discourage a school from making a decision to become an academy. We had over the years attempted to push back with local authorities, both in terms of really the principle of charging for something they were obliged to do, which is generally something which if you've got a statutory function, you don't charge for it. We weren't very successful, frankly, mainly because the DfE never really got behind some of those arguments. And now, of course, we've got a DfE who are not particularly focused on academies and seem to be jolly keen on supporting local authorities. And so we expect that debate to get tougher, and for local authorities to be more emboldened in terms of charging and indeed introducing conditions into commercial transfer agreements. We've seen that in some local authorities where they've been pushing back, for example, on admissions and place planning functions, putting conditions in the CTA, obliging schools to actively consider admissions requirements, place planning. Now we've got legislation that's coming in to do the same job, but the other area that we've seen local authorities kind of push the debate on the back of conversion is with regard to deficits, costs, and provision of service level agreements, so trying to enshrine more of those SLAs post academy, which of course they were never allowed to do previously. So I think we'll just see what's developing in terms of the approach to a conversion and CTAs. Other thing to bear in mind, of course, is that local authorities have been struggling with capacity for quite some time, and a lot of them are now running quotas for conversion, and I expect that to get more difficult as they are prioritising other need over conversion. I think just to conclude with one theme which we keep coming back to, which is the increasing regulation of the system. I think what I'm expecting to see in truth is more opportunity for us to consider whether in fact decisions by local authorities exercising these new powers, and indeed the DfE in terms of exercising powers to direct academies and to an extent maintain schools, and whether in fact we need to consider more judicial review of those decisions, particularly in the early days where there might be a bit less experience, a bit less guidance, and monitoring to see whether those powers are being exercised proportionately, reasonably. So if we're not very happy with what's happening, that might give us some scope to push back. And perhaps just to conclude with, the one thing we are going to see over the next few months is new guidance on absolutely everything. So a new admissions code, new Ofsted inspection regime, new schools causing concern guidance, new keeping children safe in education guidance, and certainly a new Academy Trust handbook with I'm sure more detail in there in terms of expectation and regulation. What's interesting about all of those documents, all of that guidance, is some of which of course is statutory guidance which you must comply with, and some elements are more discretionary, but probably an increasing emphasis on statutory guidance and the musts. So it's just becoming a tougher place to do what is a difficult job at the best of times. I'm probably going to stop there and allow us a few minutes for questions, although I know you've been asking questions as you've gone along, so hopefully you feel you've got a good flavour of what's coming down the tracks. But yes, if anybody would like to share any observations about all of this, or ask any questions whilst you've got the last 10 minutes of us, I suppose. Thank you. We've probably exhausted you, haven't you?
There's a couple of questions in the comments. One from Bill. I don't think this has been answered. Can you comment on the powers of the Secretary of State when seen in the light of the duties of directors under the Companies Act?
Sorry, Ada, ask that question again.
Can you comment on the powers of the Secretary of State when seen in the light of the duties of the directors under the Companies Act?
Okay, that is an interesting question. I mean, Companies Act and I guess certainly the Companies Act is the main piece of legislation governing corporate governance. It tends to be very lightweight. It's not even as extensive as the Charities Act, and obviously the Charity Commission regularly produce guidance for trustees. Directors, of course, of Academy Trusts are trustees for the purposes of charity law, and so Companies House tend to be quite lightweight, Charity Commission less so, DfE even less so. So I think you're going to be probably if you're non-compliant, it'll be with DfE guidance first, and Companies Act last. I think the only interesting area that I've seen where there is some challenge is in relation to conflicts of interest, and managing conflicts of interest in particular, which is a statutory duty under the Companies Act as well as under the Charities Act.
I think it's all much wider than this. When you've got a Secretary of State making statements that conflict with the statutory duties of a director, which go all the way back to the Cadburys, and now you've got Professor Mervyn King in South Africa leading global groups on the development of good corporate governance, which is coming in. I happen to belong to that group, and I see sticks being waved as multi-academy trusts, where clearly there would be a conflict for us as directors under the Companies Act. Now, the fact that the Companies Act hasn't been implemented, well, it's been implemented, but hasn't been enforced, is a deficit on behalf of the enforcers. It doesn't mean that's not what's written in the legislation. The 2006 Act, I don't think anybody has ever read the whole thing because it's so big. And, you know, so it outstripped FSMA, the Financial Services and Markets Act, which was the biggest. And nobody's actually read it. But the demands on directors are very, very clear. And it's not for the Secretary of State to say to me, as a statutory director of a trust, you cannot do this. Because Companies Act takes precedence, in my view.
I think it's that fundamental duty to act in the best interests of the company, charitable purpose, which of course is intrinsic. Yeah, well, indeed, it is. And that's where I think you get sometimes this the problems with conflicts of interest as well, in terms of who is kind of directing you to do something. But I think the only answer to that question is to use the judicial review powers. So if a Secretary of State is acting in effect outside of a proper remit, in directing the directors to do something, then I think that's how you would push back, and you would be arguing your fundamental duty under the Companies Act and in charity law.
With current funding regimes, I can't imagine us being able to fund judicial review actions. You know,
well, so the other thing that's quite interesting, and we've done this a number of times over the years, particularly with local authorities, less so DfE in truth, is use the power to complain about a local authority's actions to the DfE, which you've got rights to do under the Education Acts themselves. And what we often find is that sometimes it's enough just to make a comment. It's enough to highlight the issues which haven't been fully appreciated perhaps by DfE or even by the local authority, you know, the wider local authority team, and so you can use some of these statutory processes to raise an issue which is genuinely causing concern to the school. And obviously, as a family of Catholic schools, we work together. We have the support of the diocese, we have the support of the Catholic Education Service, and they regularly take up issues, whether they're very specific to Catholic schools or a bit broader than that. They take them up with the DfE and the Faith Schools team. And as far as I can tell, there is still a high level of engagement between DfE officials and the Faith Schools group, and that's obviously the National Society for the Church of England as well as the Catholic Education Service. So I spoke to Christine a couple of days ago, and she said they're just inundated at the moment. They have got meetings coming out of their ears because all of this new legislation is just creating a lot of questions and the impact for Catholic schools in particular. So there's a lot to take on board, and the implications I think are going to be, you know, we're going to be working hard on this for quite some time.
Thank you.
Could I just offer a moment of thanks to Ada, Teresa and Andrea? Thank you so much. We've been inundated with the amount of information that we've had tonight, and you did preface that by saying that you were trying to give us a synopsis of the things that are coming out. But it has led me to believe that as a diocese, we need to kind of unpick this even further. And you've given us a lot of food to reflect, a lot of things that we need to reflect upon. And I think there were three key areas that we focused on this evening. And we need to come together and look at how that's impacting us. So I thank you greatly for what you've supported us with this evening. But I'd also like to thank everybody who's joined us online this evening, not just yourselves, because you've given over all your expertise and your knowledge, but all of you out there, head teachers, and especially our directors and our governors who are volunteers in this effort. We're trying our best to drive our way through an ever-changing road. It's a bit like a river meandering through a terrain that you have no idea where we're going to land. But if we can work together, we'll find a solution. And I think it's that collaboration and coming together and sharing our experiences. And this evening, Bill in particular, thank you so much for your comments that you've brought to this. I would like to bring this back personally to a diocese, and let's get round the table and let's really think about what's going to impact us and how we can move ourselves forward in the future. But we couldn't have done that without your support, ladies, and I'm sure we're going to pull on your support moving forward as well. And my final thanks goes to Debbie, because you have put this all together tonight for us. So thank you very much.